Hello everyone, I'm Aratrika Bhaumik and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court of India and then move on to High Courts and other subordinate courts. If you like our content, please do support us by liking and subscribing to our YouTube channel. Let's begin. The Supreme Court of India today remarked that the counter affidavit filed by the Gujarat government in opposition to PILs challenging the premature release of 11 convicts in the Bilkis Bano case is very bulky. Justice Ajay Rastogi today remarked during the hearing, and I quote here, "A series of judgments are stated. Where is the factual scenario? Where is the application of mind?" Solicitor General of India Tushar Mehta, appearing for the government, responded that the judgments were only mentioned for easy reference and it could have been avoided. The Supreme Court of India has refused to entertain a writ petition filed by conman Sukesh Chandrasekhar and Leena Paulos seeking the transfer from Mandoli jail to any other jail where the present Director General Prisons of Delhi is not in charge. On August 26, by virtue of the Supreme Court's order, on August 23rd, the duo was shifted from Tihar jail to Mandoli jail in Delhi. The court's order came after Sukesh had filed a writ petition under Article 32 of the Constitution of India, alleging that officials in Tihar are torturing him for not meeting the demands of money. The Supreme Court of India today issued notice in a plea filed by the National Green Tribunal challenging the order of the Bombay High Court, which has quashed administrative notices issued by the Registrar General of NGT, transferring cases from the Western Zone bench at Pune to special benches at the principal seat at New Delhi. A Supreme Court bench comprising Justices B.R. Gavai and B.V. Nagaratna was told by Senior Advocate Arvind P. Dattar, who appeared on behalf of the NGT, that the High Court's order will have pan-India ramifications as the notices have been quashed in their entirety. This would essentially mean that transfer of cases from other zonal benches to Delhi will also be affected, and not just the transfer from the Western Zone bench. The Union Law Ministry has submitted before the Supreme Court of India that it cannot direct the Parliament to frame or enact any law. Thus, the PILs filed before it seeking a uniform civil code in the country must be dismissed as non-maintainable. In response to the PIL filed by BJP leader and advocate Ashwini Upadhyay seeking uniformity in the personal laws regulating marriage, divorce, maintenance and alimony, the ministry said that a writ of mandamus cannot be issued to the legislature to enact a particular legislation. A division bench of the Supreme Court of India issued notice on a writ petition seeking uninterrupted and continuous 4G mobile internet services in the Union Territory of Jammu and Kashmir. The petitioner is a non-profit society called Private Schools Association J&K that represents the interests of over 3,800 member schools in the Union Territory, according to the petition. The Home Department of Jammu and Kashmir has been arraigned on the ground of grave and ongoing violation of the fundamental right to education of students, as the department has allegedly continued slowing down mobile internet speed to 2G. The Supreme Court today dismissed a transfer petition filed by P. Raghu Ganesh, one of the accused in the custodial death case of trader P. Jairaj and his son J. Benix. Ganesh, who was a sub-inspector of the Sathankulam police station where the custodial death of the father and son duo happened back in June 2002, saw the transfer of the trial from Tamil Nadu to Kerala. The Supreme Court of India reiterated that the schedule for admission to postgraduate medical courses must be followed strictly. The bench of Justices Ajay Rastogi and C.T. Ravikumar observed thus, while setting aside the judgment of the High Court of Calcutta directing the West Bengal University of Health Sciences to grant admission to some candidates after the cut-off date. The Delhi High Court today denied bail to student activist Umar Khalid in the larger conspiracy case of Northeast Delhi riots. Khalid has been in custody since September 2020. a division bench of Justice Siddharth Mridul and Justice Rajneesh Bhatnagar dismissed Khalid's appeal challenging the trial court order denying him bail in the case. The bench said that Khalid's name finds a recurring mention from beginning of the conspiracy till the riots, adding that he was a member of several WhatsApp groups like the DPSG and the Muslim Students of JNU, and had also participated in various conspiratorial meetings. Text ridiculing phrases like Ram Mandir and Achhe Din aimed at the democratically elected government in Kabir Kala Manch's place at the Elgar Parishad event back in 2017 incited hatred and passion and indicate a larger conspiracy the Bombay High Court has held. In its detailed order refusing bail to accused Jyoti Jagtap under the UAPA, the High Court also took exception to the mention of Gaumutra, calling the PM an infant, atrocities of Peshawars towards Dalits and atrocities of Dalits in today's India, etc. The Delhi High Court today observed that the attack on police personnel during the 2020 Northeast Delhi riots by women protesters in front only followed by other ordinary people and engulfing the area into a riot is the epitome of a premeditated plan and would prima facie be covered by the definition of a terrorist act under the Unlawful Activities Prevention Act. Denying bail to student activist Umar Khalid in the Delhi riots' larger conspiracy case, the division bench of Justice Siddharth Mridul and Justice Rajneesh Bhatnagar said that if the charge sheet is taken at face value, there appears to have been a premeditated conspiracy of causing disruptive jam and pre-planned protests at different planned sites in the city of Delhi. Union Law and Justice Minister Kiran Rijiju on October 17th said that the people of the country are not happy with the collegium system and that as per the spirit of the Constitution of India, it is the job of the government to appoint judges. He further said that people can see the politics among the leaders, but they do not know the politics going on inside the judiciary while appointing judges, as the deliberations during the collegium meetings are intense. He added that the system is opaque and not transparent. Thank you. Keep watching Courts Today on LiveLaw for more such updates. If you like our content, please support us by liking and subscribing to our YouTube channel. See you tomorrow.